The night my son-in-law handed me a legal document and told me to sign it, I noticed his hands were completely steady. That detail stayed with me. A man asking his 68-year-old father-in-law to surrender control of a family business built over 31 years. And not a single tremor, not even the decency of discomfort. Just that thin, rehearsed smile, and the sound of sleet ticking against the window of my own kitchen in Oakville. I did not sign anything that evening. I told Trevor I was tired from the drive back from the cardiologist in Hamilton, that I'd look it over in the morning. He nodded pleasantly, folded the papers back into his jacket, and helped himself to another cup of my coffee. By morning, I had read every line of that document 4 times. By the time my daughter Simone came downstairs, I had already called my solicitor. But I am getting ahead of myself. To understand what happened in that kitchen and everything that followed, you need to know how we got there. Because it did not begin with a legal document. It began 3 weeks earlier. On the afternoon, I walked out of the Oakville Cardiac Center with a clean set of test results, a prescription for a blood thinner, and a piece of advice from my cardiologist to reduce my workload. Moderate stress, she said. Delegate more. Let the people around you carry some of the weight for a while. I drove home along the lakeshore, watching the November sky sit gray and flat over Lake Ontario. I had built Harmon millwork and cabinetry from a rented workshop on a gravel lot in Burlington. 31 years, custom cabinetry, commercial millwork, residential projects across southern Ontario. My wife Pauline had handled the books for the first 15 years before the cancer. After she passed, I hired a proper accounting firm, but I kept my hand on everything else. The business was not just income, it was the shape of my days. It was the reason I got up at 5:30 every morning. My daughter Simone was 34. She had joined the business 6 years earlier, right after she finished her business administration degree at McMaster. She was sharp, genuinely sharp, and I had handed her the operations director title with real pride. I thought I had done everything right. Trevor was her husband of 4 years. He had his own background in commercial lending, or so he had told me when they started dating. He was well-dressed, well-spoken, always asking the right questions at the right moments. The kind of man who makes a good impression on fathers. The kind of man I should have looked at more carefully. When I came home that afternoon, they were both at my kitchen table. Simone made tea. Trevor sat across from me with that level, pleasant expression he wore like a uniform, and told me he'd been thinking about my health situation and that the two of them had a proposal. A restructuring, he called it. A way to protect the business and make sure I could actually rest the way my doctor was recommending. I listened. I asked questions. Trevor had answers ready for all of them, smooth and sequential, like a man who had practiced the conversation several times before having it. The short version was this. I would sign over operational authority to Simone, effective immediately, while retaining my ownership stake. Trevor would step into a newly created Chief Operating Officer role. They would handle the daily management. I would stay on as a senior advisor, my name still on the door, no pressure, no stress. I told them I appreciated the thought. I said I would think about it. What I did not say was that something in Trevor's eyes, in the precise way he watched me while Simone spoke, had sent a cold, slow current through my chest that had nothing to do with my heart condition. I had spent 31 years reading people across boardroom tables and job site trailers. That instinct does not retire, just because your cardiologist tells you to slow down. That night I lay in bed and thought about the past year. Small things I had noticed and then let go. Trevor taking calls in the driveway and coming back inside, with a tight smile that dissolved too slowly. A comment he had made at Easter about the company's real estate assets, the Burlington facility, the Oakville showroom, and whether I had considered the equity sitting idle in them. The way he had started attending our supplier meetings without being asked, quiet, observant, absorbing. I was not a suspicious man by nature, but I was not a foolish one either. The next morning I drove to my solicitor's office in downtown Burlington before the business day started. I had known Helen for 22 years. She had handled Pauline's estate. I trusted her the way you trust someone who has already seen the worst days of your life and helped you get through them. I told her about the proposal. I described the document Trevor had brought. I told her about my instinct. Helen listened without interrupting. Then she asked me one question. Had Trevor ever given me documentation of his professional background in commercial lending, his credentials, his registrations, his employment history? I realized I had never asked. She told me to go home and act normally. She would make some calls. I left her office and drove to the Burlington facility. I walked the floor, checked in with my production manager, drank a bad coffee from the machine in the break room, and acted like a man with nothing particular on his mind. 3 days later, Helen called me to a second meeting. She had found things. Trevor's background in commercial lending was real in the sense that he had worked for a mid-size lender in Mississauga for approximately 2 years, 6 years prior, before being let go under circumstances that had resulted in a civil settlement with a non-disclosure clause. Helen's contact at the Ontario Securities Commission had flagged his name in connection with a complaint involving a private mortgage syndicate that had collapsed, leaving several retail investors short. Nothing criminal had been proven. But the pattern was there for anyone willing to look. More troubling was what Helen's financial investigator had found when she began tracing Trevor's personal debt structure. He had a first mortgage on the home he and Simone owned in Mississauga, the home I had contributed the down payment to as a wedding gift. He had a second mortgage on the same property, taken out 18 months earlier, that Simone almost certainly did not know about. And he had a line of credit attached to a numbered company, registered in his name in Alberta, secured against an asset described in the filing simply as commercial property, Ontario. Helen looked at me across her desk and asked if I had any commercial property in Alberta. I did not, but I had a Burlington facility and an Oakville showroom, both owned outright by the business, both with assessed values sitting comfortably above $2 million each. I drove home slowly. The highway was slick with early snow, and I kept both hands on the wheel and my eyes on the road ahead. I was not angry yet. I was the way you get before anger, when everything inside you goes very quiet and very focused, and the world outside seems slightly far away. By the time I pulled into my driveway, I knew what Trevor was doing. He had been positioning himself for this for at least 18 months, probably longer. The numbered company, the secured line of credit, the manufactured urgency of my cardiac situation. These were not coincidences. He needed operational authority over Harmon Millwork so he could use the company's real estate as collateral to address whatever financial hole he had quietly dug for himself. And he needed it done quickly and cleanly and with my signature at the bottom of the page. What Trevor did not know, because I had never mentioned it to anyone, was that I had restructured the company's ownership agreement 11 years earlier, after a competitor tried a hostile acquisition through a minority shareholder dispute. My solicitor at the time had recommended a specific shareholder protection clause embedded in the corporate bylaws. The clause required that any transaction involving the company's real property assets, sale, encumbrance, or assignment of equity, required the wet ink signature of the founding shareholder, verified in person at our primary chartered bank, accompanied by independent legal counsel, confirming the signing was voluntary and uncoerced. Not a power of attorney, not an operational authority transfer, me in person, at the bank. With my own lawyer present, Trevor had no idea that clause existed. He had never asked to see the corporate bylaws. He had spent a year and a half grooming his way toward a door that was quietly, invisibly bolted from the inside. I poured myself a scotch that evening, the good one Pauline had given me the Christmas before she passed, and I sat in the armchair by the living room window and looked out at the snow coming down over the backyard. The light was fading. The yard was still. I thought about the fact that my daughter was in that house in Mississauga, presumably believing that her husband was helping her father and building a future. That was the part that cut deepest. Not the money, not the property. Simone. I called her that evening and asked if she would come for dinner the following Sunday, just the two of us. I told her I wanted to talk about the business transition, that I had been thinking it over and had some questions. She sounded pleased. She said Trevor would be glad to hear I was coming around to the idea. I said that Sunday dinner would be better as just the two of us. I told her I always thought better without a crowd. She laughed at that, the real laugh, the one that sounded like her mother's. Sunday came. I made roast chicken the way Pauline used to, with the herbs from the pot on the kitchen windowsill. Simone arrived at 5:30, her coat dusted with snow, and we sat at the kitchen table the same way we always had. And for a while it was just the two of us, and the smell of the food, and the lamplight, and the sound of the weather outside. After dinner I put the dishes aside and set a folder on the table between us. I told her I needed her to look at some documents before we talked about anything else. She looked at the folder. Then she looked at my face. She had her mother's eyes, gray and direct, and they told me she already sensed that the evening was not going to be what she had expected. I opened the folder. I had arranged Helen's investigative report in plain language, chronologically, without editorializing. I had included the registered mortgage documents for the Mississauga house, showing the second charge Trevor had taken out. I had included the Alberta corporate registry filing, showing the numbered company and the secured line of credit against commercial property, Ontario. I had included the OSC complaint file summary that Helen's contact had provided, with the relevant portions highlighted. I did not speak while she read. I got up and made tea and set it beside her and then sat back down. She read for a long time. When she finished, she put the last page face down on the table and pressed both palms flat against it and stared at the tablecloth. The silence in the kitchen was very heavy. The furnace clicked on somewhere in the house. She asked me how long I had known. I told her 3 weeks. She asked why I had waited 3 weeks to tell her. I told her I needed to make sure I had everything and that I needed to be sitting across from her in person when I did. She nodded very slowly. Her jaw was tight. She was holding herself the way her mother used to hold herself when she was deciding whether to cry. Then she asked me what I wanted to do. I told her I was not going to sign anything. I told her that the company's real property was protected by the shareholder clause and that Trevor could not touch it without my physical presence at the bank with independent counsel, regardless of any operational authority transfer. I told her that meant his entire plan had a wall in the middle of it that he had never thought to look for. She asked me what happened when he figured that out. I told her that was up to her. She was quiet for a moment. Then she said Trevor had mentioned money problems once, about 8 months ago, vaguely, and she had asked directly, and he had told her it was a cash flow issue with a side investment that was resolving itself. She had believed him because she had had no reason not to. Then she said, I want to know everything he has done. I want to see all of it. That was when I knew which way this was going to go. Here is what happened next, because it moved quickly once it started moving. Simone went home that Sunday night. She told Trevor the dinner had been fine, that I was warming to the idea that she thought I would come around before Christmas. She was composed and precise about it. And I found out later that while she was saying those things, her hands were steady, and I thought she got that from her mother. Over the following 2 weeks, while Trevor believed he was making final preparations for a clean handover of operational authority, Simone gave Helen's investigators permission to access her joint accounts. What they found confirmed and extended the picture we already had. Trevor had been drawing down a personal line of credit attached to a real estate syndicate, structured through the Alberta numbered company. The syndicate had been funded in part by private investors, some of whom had already filed complaints with provincial regulators. The amounts were substantial. Trevor owed somewhere between $800,000 and $1.2 million, depending on which obligations were already in default, and several of the creditors were not the kind of people who accepted delays graciously. He had not told Simone any of this. Not the syndicate, not the investors, not the defaults. He needed Harmon Millworks real estate equity, approximately $4.3 million across both properties, to collapse the debt and emerge clean. My cardiac situation had presented him with exactly the justification he needed to push for the operational transfer. He had moved decisively because he had no other option. Helen filed the civil fraud claim on a Thursday morning. At the same time, she submitted a formal complaint to the Financial Services Regulatory Authority of Ontario, referencing the secured line of credit, the undisclosed second mortgage, and the misrepresentation of asset ownership in the Alberta filing. She also sent a registered letter to Trevor's solicitor, advising them that any attempt by Trevor, or any entity associated with him, to record, transfer, or encumber any real property asset connected to Harmon Millwork and cabinetry would be immediately contested and would constitute grounds for criminal fraud proceedings. That letter arrived at Trevor's solicitor's office on the same Thursday. I did not hear from Trevor that day, or that evening. The following morning, my phone rang at 7:45. I was in the kitchen. The coffee was on. I looked at the screen, saw Trevor's name, and let it ring through to voicemail. I poured my coffee, sat down, and waited. He called again at 7:52, then at 8:04, then 3 more times in the following half hour. I did not answer any of them. I did listen to the voicemails. The first one was controlled, professional, almost. He said there appeared to have been a miscommunication with his legal team, and he wanted to connect before anything escalated unnecessarily. He used the word unnecessarily twice. The second voicemail was less controlled. He said he knew I had spoken to Helen, that he could explain the Alberta situation, that I was not seeing the full picture, and he really needed me to call him back before this got out of hand. His voice had a catch in it on the last sentence that he was trying to suppress. By the fifth voicemail, 2 hours later, the professionalism was entirely gone. He was somewhere that sounded like a parking garage. His voice echoed. He said he had people he owed money to, who did not operate through lawyers and court filings, and that he had been trying to protect Simone from knowing the details, and that if I would just let the property transfer go through, he could make everything right, and that he was asking me, as the man who had known him for 4 years and walked his daughter down the aisle, to please pick up the phone. I sat with that voicemail for a long time. Then I called Simone. She picked up on the first ring. I told her about the calls. I read her the relevant parts of the fifth voicemail. She was silent on the line for a moment, and then she said, "I think he's been lying to me for longer than either of us know." She was right about that, as it turned out. I called Trevor back at 11:30. He answered before the end of the first ring. He started talking immediately, fast and uneven, cycling between apology and justification, the way frightened people do when they have run out of strategies. He said the investment had seemed solid, that the market had moved against him, that he had only brought Simone into the plan when he thought it would work, that he had never intended for her to be exposed to the risk. He said my name twice in the first minute, using it the way people use a name when they are trying to re-establish a connection they can feel slipping away. I let him finish. Then I said, "Trevor, the shareholder protection clause in the corporate bylaws requires my physical presence at the bank to transfer or encumber any real property asset. No signature, no power of attorney, no operational authority transfer changes that. I installed it 11 years ago, and I never mentioned it to anyone. You have been planning this for 18 months against a door that was never going to open." The silence on the other end of the line was total. He said, "What?" I said, "There is nothing for you here. There never was." He said my name again, very quietly this time, and his voice had changed completely. The strategy was gone. The preparation was gone. He sounded the way people sound at the precise moment they understand that the ground they were standing on was never there. I told him that Helen's complaint was already with FSRA and that the civil claim was filed. I told him that if his creditors were the kind of people he had described, the wisest thing he could do was contact them directly and begin negotiating, because there was nothing coming out of Harmon Millwork that was going to help him now. I told him that Simone would be in touch with him through Helen. Then I said, "I built this company for 31 years. You have been in this family for 4. I want you to think very carefully about which of those 2 things you should have respected more." I ended the call. I sat at the kitchen table for a while after that. The coffee had gone cold. The house was very quiet. Outside, the first real snow of the season was settling evenly over the backyard, covering the garden, covering the fence, covering the old apple tree Pauline had planted 20 years ago near the back corner. I did not feel triumphant. I felt the particular exhaustion that comes not from the fight itself, but from recognizing how long the deception had been running before you saw it. I felt the grief of it, the waste of it. But underneath that, something else. A steadiness I had not expected. Trevor did not contest the civil claim. His solicitor filed a response that was, in Helen's professional assessment, the paperwork equivalent of a man holding up his hands. The FSRA complaint triggered a broader regulatory review of the Alberta syndicate. 17 private investors had filed or were preparing to file complaints. Trevor's exposure was significant enough that his own legal team appeared to be advising him that cooperation was his best remaining option. Simone filed for separation in December. She moved back into the Oakville house temporarily while the legal process proceeded. We did not talk much about Trevor directly. We talked about other things. We made a lot of dinners together. We drove out to the property in Burlington one Saturday in January and walked the floor of the production facility together. Just the two of us, the way I used to bring her when she was small, before any of this. She told me, standing in the middle of that floor with the sound of the machines and the smell of fresh-cut maple around us, that she was sorry she had not seen it. I told her that was not hers to be sorry for, that a person who is being deceived is not responsible for the deception. She was quiet for a moment, looking out across the production floor. Then she said, "I thought he was going to help you build something that lasted." I told her, he was never going to build anything. He was only ever looking for something he could take apart. In the spring, I made two decisions. The first was that Simone would take on the role of president of Harmon Millwork, with full operational authority, effective in September. She had earned it 6 years before I was ready to give it to her. That was my failure to correct, not hers to wait indefinitely for. The second was something I had been thinking about for years, but had never acted on. I established a small trades apprenticeship fund through the company, directed at young people in Halton and Peel regions who could not otherwise afford the fees and equipment costs of entering the skilled trades. Cabinet makers, millworkers, joiners, the people who build things that last. Helen came to the small reception we held to announce the fund. She stood in the showroom with a glass of sparkling water and told me that in 22 years of practice she had seen a lot of these situations and that most of them did not end the way this one had. I asked her what made the difference in the ones that ended well. She thought about it for a moment, and then she said, "The ones that end well are almost always the ones where someone had been quietly building a wall for a very long time before anyone tried to come through the door." I thought about Pauline, who had sat across from me at the kitchen table 32 years ago and helped me write the first business plan on a legal pad, who had laughed at my handwriting, who had told me that the only way to build something that no one could take from you was to make sure you understood every brick of it yourself. I thought about the clause in the corporate bylaws that I had never told a single person about. Some walls are built in secret. That is precisely what makes them strong. I do not know exactly what happened to Trevor after the civil proceedings concluded. I know the FSRA review resulted in his permanent disqualification from holding any financial advisory designation in the province of Ontario. I know that at least one of his creditors pursued a separate claim through the courts. I know that he is no longer in Oakville or Mississauga. I know that Simone is well. I know that she came over for dinner last Sunday and brought a bottle of Ontario Riesling, and we sat at the kitchen table until well past 10, talking about the spring production schedule and a new residential contract she is excited about, and the apprenticeship program, and 100 small things that matter more than I used to let myself notice. When she left, she stood in the doorway and turned back and said, "Thanks, Dad, for all of it." I told her to drive safely. The roads were icy. I closed the door and stood in the hallway for a moment in the quiet of the house. 31 years ago, I drove to a gravel lot in Burlington with a truck and a set of second-hand tools, and a belief that if you built something carefully enough, and honestly enough, and defended it patiently enough, it would outlast the people who tried to take it from you. I still believe that.